Yes, because I said I'll come back to it.
Yeah.
Now, I've gone through the record. It is indeed so that there are portions where Constable Zungu mentions him being in a meeting with Lieutenant
Shabani.
Dishabane. At some point, Buthelezi is also there. At some point, Warrant Officer Makubo is also there. He, however, I searched and searched. I couldn't find exactly the location where those meetings took place. He was saying that when he was led in examination in chief. Unfortunately, that information relating to the venues where those meetings were taking place were not elicited. He also repeated the same version under cross-examination by my colleague, Mr. Ramusipeli. I couldn't find a point where he mentions that at some point when he was amongst the people that I've mentioned, he also came across accused number one.
No, you didn't read it well. Zungu pertinently mentions that he attended a meeting where Shabani was present.
Yes.
Sibia, sorry, is that David Sibia?
Yes, General Sibia.
General Sibia. Makubo and
Buthelezi and Dishabane.
And
yes.
There was one or two other guys.
Yes.
And that meeting took place at the offices of the Shabani. It was the Shabani, right? At Kloof. Mr.
Yeah,
Baloi, is that correct, sir?
Yeah.
Yes, indeed. One can see that from page 57.
Yeah, that's what I read.
57, 58.
Yeah, that's when Makubo came with a version that Zungu is a liar because he, Makubo, is the person who arrested accused number five.
Number five, yes.
Yeah, but that meeting took place there at Kloof, okay?
At Kloorkop.
Kloorkop, sorry.
Yes. So in any event, my lord, we don't intend to make a meal out of that.
Okay, fine.
But another point that came out yesterday, it was with regard to Mr. Dishabane. I think the court indicated that it's the duty of the defense to call him.
No,
I don't know whether it's a Mr. or a what.
No, I didn't say that. I said Mr. Mkumezulu says he intends calling him. And when you were supposed to call him in the trial, within a trial,
yes,
Mr. Mkumezulu thereafter decided he's no longer calling him. You don't remember that, Mr. Ramusipiti?
What transpired, my lord, is that indeed on that day, General Shabani was present in court.
Yeah.
However, it then emerged that he's on the list of state witnesses.
Right, yeah.
And because the state's case is not yet closed,
Right.
he couldn't call him, my lord.
Yeah, you're right. Okay, fine.
but nonetheless, my lord, the state pertinently indicated that they would be calling him.
Is it?
Yes.
Okay.
That is when Zungu was testifying and he was referring to the conversation that he had with Dishabane. The state requested that that information be provisionally received because they'll definitely be calling Mr. Dishabane.
Yes.
Thank you, madam.
Okay, fine, let's continue. Is that correct, Mr. Baloi?
Maybe two issues. The first one regarding the fact that Zungu never mentioned that they met at Kloorkop. If one looks at page 55 of the record, clearly at lines 20, it says the same year, 2019, I received a call from General Shaban who asked me to meet him at his cluster office in Kloorkop.
Yeah, fine.
And regarding the issue as to whether the state is going to call General Shabani, initially we indicated, my lord, that he's on the list of state witnesses,
Okay.
but at the later stage we made it clear that we are not going to call him, and we intimated that we are making him available to the defense.
Okay, fine. Thank you. Yes, Mr. Mnisi, let's proceed then.
As it is the court, my lord. Otherwise, that is, it's not a big point. Thank you, my lord. Now, Brigadier, thank you, and good morning to you.
Good morning to everyone, Mr.
Thanks. Now, you made mention of the fact that, remember yesterday I said when you spoke about the presentation that you made to the office of the DPP, it would have been something that would have happened in the boardroom, you guys sitting around the table and you making an exposition of the investigation, and then you said, no, it wasn't a form of a memorandum, not so.
Babingelela ke fakazi bathi khumbula khona njalo izolo ngesikhathi kade ummeli akhuluma ngodaba noma ngesikhathi bekakubuza ngodaba lwepresentation ukuthi ngabe mhlawumbi ke kade nihleli kanjani ukuthi umhlangano uhlezi mhlawumbi kutafula kade nihlezi khona ke lapho ke bese wena kwabatshela malana nalokho kade unakho ke bese wathi wena cha kade kungasinjalo ke lapho ke kade wena ubhalile uhlelo balibiza ukuthi memorandum.
That is correct, my lord.
Athi yebo kuqiniso lokho.
Now, thank you, Brigadier. Now, what was the factual, what were the facts that you presented in that memorandum on which you requested the state to make their decision on?
We don't mean to interfere with my colleague's cross-examination, but yesterday at length he canvassed this issue, which in our view, it's irrelevant. And secondly, my lord, what happened when Brigadier Gilinda briefed the office of the DPP, it's irrelevant. It's a collateral issue, my lord, that we submit, in our view, should not be canvassed during these proceedings. It's like what happens during consultation. You know, it remains there, my lord. It shouldn't be brought into the courtroom.
That is misinformed, my lord. Remember that briefing or that memorandum is the basis why this trial is happening. So there's nothing secret about it. It could have formed the basis why these accused persons were ultimately arrested and charged with the offenses that they were charged with today. So there's nothing irrelevant on that. Yes. We are entitled as a defense, and more particularly these accused persons are entitled to know what were the facts upon which the state decided to indict them to come and stand trial before this court. What is wrong with that? They are entitled to.
Yeah,
And
fine.
unless there's something which is being hidden.
Dr. Sibana just reminded me, my lord, that the late Mr. Mgomezulu made Brigadier Gininda to read through his affidavit on which the application for a warrant of arrest was based. So the information is already before court, my lord.
My lord, I'm not talking affidavit here. I'm talking the factual basis upon which the state decided to arraign these accused persons to come and appear here. I don't know what was contained in that memorandum. All that I want to get from this witness, who is the lead investigator on this court, what is it that, what were the facts that he laid before the state on which he requested the state to make a decision on, which later on then the state indeed took a decision to arraign these people, these accused persons to come and appear here before court. There's nothing untoward.
Yes, sir.
Thank you.
Manje ke kade bebuza ke ummelweni bomnumzana ukuthi kahle kahle ngabe malana nodaba lomhlangano lethimba labashushisi futhi nethimba lawa labaseshi becala ukuthi kade kuyini le amaphuzu wabo kade badigida ke lapho ke kumhlangano wabo kade benawo noma yini amaphuzu kade bekhuluma ngawo ke ngesikhathi kade benomhlangano.
Before you start, Brigadier, I'm going to request you to take it point by point, because I'll also be taking notes here. I'll be very wary if I were to hear you saying something very, 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 very long, which I will end up been confused and coming back to you, what is it that you are saying there? Just take it point by point up until then you say, no, yeah, I'm done. Do you understand, sir?
Bacela ke kufakaza ukuthi uma ngaba akhuluma ke anciphisa inkulumo yakhe ke ashiphuze lokuqala ke bese anikeze ummeli isikhathi sokuthi abhale phansi ngoba akafuni ukuthi ummeli ufakazi akhulume inkulumo eningi noma udaba olude bese akhohlwa ukuthi bekakhulume ini ufakazi bese futhi abuye futhi ambuze ukuthi konje kade bothizeni qala.
I do understand, my lord, but
you.
obviously the difficulty I may have, I will try to summarize because I don't have the memorandum with me, and that was done in 2020. But I do have a recollection of what it contains. So insofar as what it contains, I will go slowly so that Advocate Mnisi can write and take notes. But,
Yes.
but it will be a summary of what I recall, and then I'll refer to those points, my lord.
Athi akasakhumbuli kahle hle ukuthi umhlangano lo kade uqukethe ini noma amaphuzu omhlangano kade bequkethe ini kona ke noma kade kuyini amaphuzu kade khona ke ngaphakathi memorandum yakhe kepha ke lapho ke uzamthi anciphise malana nenkulumo leke ngoba lokho kwenzeke esikhathini seminyaka eminingi edluleke ngomnyaka ka2020.
Now, my recollection, my lord, is that in the memorandum, you first indicate the background of the case, what transpired. Example, now you'll refer to the incident that took place on the 26th of October. So it's a summary of what happened in the case. You summarize those facts. And that's what I did.
Athi koqala ke lapho kokwenza ke isikhangiso ke secala leli lonkana ukuthi ngabe kahle hle yini eyenzeka malana necala leli futhi ngabe icala lilenzeka ngaliphi ke ilanga bese ukhumela ngala nge26 zenza zaka October ngomnyaka ka2014.
And then you indicate as to where the investigation led me to, and specifically led me to accuse 1, 2, 3, 4, 5, my lord, before court.
Bese ke lapho ke yabhala ukuthi usesha kwecala ngesikhathi bophenya icala waqala kuphi ke lapho ke futhi maqeda lapho ke bese wahamba waya kumsolo oqala umsolo wesibili umsolo wesithathu wesine futhi nowesihlanu nokuthi yini yamkhokhela kuthizeni athole abasolo.
I will then, under accuse number 1, my lord, indicates the evidence that we have collected at that stage that was contained in the docket. That will talk to confession statements that were made by witnesses that we had at the time, under accuse number 1.
Futhi athi ngaphansi komsolo oqala ke lapho ke kunodaba lweyitetimende ke zofakazi kade beyitholile futhi nodaba lama confessions malana naye ngoqondile noma ngokukhethekile.
Just a second. Thank you.
The same exercise, my lord, will be embarked upon when it comes to accuse number 2, 3, 4, and 5. So under each and every accused name, I will indicate the evidence that was collected under that accused that we have, that connects that accused to the case. So the same principle was applied with accused 1, 2, 3, 4, 5. In other words, we'll have accused 1, evidence that connects him to the case under him, accused 2, right up to accused number 5, my lord.
Athi lapho kade benofakazi ke okhethekile noma ufakazi lowo ufakazi kade bobaxhumanisa ke nomsola wokuqala futhi uhlelo lwabo walenza kubo bonkana ke abasola ngesikhathi kade benofakazi kade benabo ke lapho.
I'm sorry, Brigadier, those are not facts. I'm going to request the court that if needs be, you go get your memorandum that you submitted to the DPP and then it be made available to us and then we work on it. Because now I don't know what evidence are you saying you had in respect of accused number 1. I don't know what evidence you're saying you had in respect of number 2. But then you're saying that is then the process that I also embarked upon. I want facts, which you presented to the state.
Athi lapho akazwisisi kahle ke mnumzana njengofakazi ukuthi ngabe kahle kahle yini lekade unayo ke malana noma amaphuzu ofakazi kade unawo ke malana nomsola uqala futhi nomsola wesibili uma ngaba uthwekena wena ninake nenza ke uhlelo olufanayo ncamashi noma uhlelo olulodwa ngesikhathi kade nebathwesa amacala noma ngesikhathi kade niphenya icala.
My lord, issues such as the memorandum or the summary of the case by the investigating officer are filed in the B section of the docket and are privileged. They've got nothing to do with the information that is contained in the A section of the docket. We submit, therefore, my lord, that the defense is not entitled to, not that there's anything to hide in the memorandum, just the issue of legal principle. They are not entitled to information or documents that are filed in the B section of the docket. But secondly, and more importantly, counsel says he wants facts. The facts have been presented before court by way of affidavits. We submit that it is therefore unfair to expect of this witness now to regurgitate facts that have already been presented before court.
As it is the court, my lord, I think probably it eludes the state's attention or mind that I'm doing cross-examination on behalf of accused number 1. I am his new counsel. I don't know what facts were presented here on record, which is the reason why that witness is there, to assist me, to assist the court. But again, I emphasize, my lord, there is nothing privileged where an investigating officer prepares a memorandum and says to the prosecutor, on the basis of this memorandum, can you please make a decision on whether you want to prosecute or you don't want to prosecute this accused person? What is privileged about that?
You know what? Have you read, is it section 279 or 179? Which makes Batohi,
It's 179.
Batohi decide whether to pursue a prosecution or not.
Yes.
So this witness can't help us because that evidence played itself in court here. Which evidence was read to, it was Johnson. Who was the guy then? The guy they used to call Sean the Sheepman. What's his name?
Sean Abrams.
Is that the one who decided?
No, it is the current NDPP.
Oh, Batohi.
Yes.
Yeah, fine. So Batohi goes over that evidence, and the decision is his, not this gentleman.
No, my lord, maybe
and
I'm...
it's no, just
Thank
listen to
you.
me. And it's a misnomer to say the state doesn't have privileged information. What this witness discusses with Batohi is privileged. The same thing as what you discuss with your witness is privileged. And that is the law.
My lord, I am saying the basis, the facts that he submits to the DPP or to the NPA and requests them to make a decision on, we are entitled to know that. And that is exactly what I'm requesting this week. And my lord, let us for a moment assume that that is privileged. He said he submitted, he made a presentation to the NPA and requested NPA to make a decision on. He did this, in this instance, he did that in the form of a memorandum. I'm simply requesting him to tell me the facts that he presented to the NPA, which facts have got to do with these accused persons that are before court here. They are entitled to know what is it that Glinda told the NPA about us, which ultimately the NPA then decided that we should be arraigned for trial here.
Okay, let's hear you. I mean, I don't want to waste time. Let's hear Glinda.
Maybe just one aspect, if I may be so presumptuous as just to mention that, to respond to one aspect. Counsel says he wants to know the facts on which the decision to charge the accused was based. That decision was based on facts contained in the dockets. And he has been furnished with copies of the statements, copies of the docket on which the information to charge the accused was premised. Nothing more, nothing less, my lord. He already sits with the information. I cannot fathom why he would want a summary that an investigating officer makes for himself and for the purpose of briefing the DPP, that he should have sight of that when he's sitting with the statements on which the decision to charge the accused was based.
Yeah, okay.
As it is the court, my lord. It is so that we have a docket, but there is nothing wrong in me while serving that docket to request this witness to give that factual basis or to give the facts on which he approached the NPA. This is cross-examination. The state cannot simply assume.
You know what, I'm going to overrule you. I just read 179. Just read what 179.
Then I'm not going to proceed.
Just read 179.
Well, the heading says prosecuting authority, section 179, subsection 1.
Yes.
There is a single national prosecuting authority in the Republic, structured in terms of an Act of Parliament and consisting of a National Director of Public Prosecutions, who is the head of the prosecuting authority and is appointed by the President as head of the National Executive, and B, Directors of Public Prosecutions and prosecutors as determined by an Act of Parliament, subsection 2. The prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to instituting criminal proceedings. I think that's what the court has just referred to. Subsection 3. National legislation must ensure that the Director of Public Prosecutions, subsection A, are appropriately qualified, B, are responsible for prosecutions in specific jurisdictions, subject to subsection 5. Then subsection 4, national legislation must ensure that the prosecuting authority exercises its functions without fear, favor, or prejudice. Subsection 5, the National Director of Public Prosecutions, A, must determine with the concurrence of the cabinet member responsible for the administration of justice and after consulting the Directors of Public Prosecutions, prosecution policy, which must be observed in the prosecution process. B, must issue policy directives which must be observed in the prosecution process. C, may intervene in the prosecution process when policy directives are not complied with. And D, must review a decision to prosecute or not to prosecute after consulting the relevant Director of Public Prosecutions and after taking representations within a period specified in the National Director of Public Prosecutions from the following: Roman figure 1, the accused person, Roman figure 2, the complainant, Roman figure 3, any other person or party whom the National Director considers to be relevant. Subsection 6, the cabinet member responsible for the administration of justice must exercise final responsibility over the prosecuting authority. And lastly, subsection 7, all other matters concerning the prosecuting authority must be determined by national legislation. That is the sum total of section 179.
Yeah, you can answer that if you think you can. But what the law says, there has got to be litis constantatio before a person can be charged in a court of law. In other words, the accused himself must plead. And when he pleads not guilty, then that is the commencement of the case. And if the accused or his counselors believe that these charges are frivolous or they are brought for a malevolent reason, then he brings an application to court for the judge to decide whether in fact there is evidence, prima facie evidence upon which a person may be charged. So even Batohi doesn't just read He inspects the docket, he goes to the law, because this is what guides him. And only after that does he charge a person. And the law specifically says a director of prosecutions may not charge a person if there is no sufficient compelling reason. Okay, you can answer Mr. Mnisi, if you are able to. That's what the law says.
May I just assist the court, my lord?
No, you don't assist me, please. I've told you what the law is. Don't assist me.
No, I'm not.
If I'm wrong, take me on appeal, take me on review, fine. But I'm saying this witness, you can cross-examine him on that very aspect.
Thank you, my lord. Thank you. Thank you, Brigadier. I said I'm requesting the facts that you presented to the Office of the Director of Public Prosecutions, on which you are requesting them to make a decision on these accused persons. Thank you. You say, in respect of accused number 1, you had evidence of a confession, you had evidence of a pointing out, you took statements from witnesses, and what else?
Bayacela ukuthi azike lapho lapho kakade bekhuluma malana nezomthetho ke ngesikhathi malana nenkulumo kammeli le bayiqhamukisileke bese umnumzana advocate Bhalo bese wafunda malana nesigaba lesi somthetho esihambisana nalo daba lo kade inkosi enkantolo idikida ke futhi nommelweni ke lapho ke bese inkosi enkantolo athi kulungile ummeli angaqhubeka abuze ke lo mbuzo ke lana ke uyamvumela ke ummelweni ke manje ecela ukuthi ufakazi aphendule ke malana nodaba lo kade noma malana amaphuzu la kade anawo ke amaphuzu lawo ke la khona ke amlekelele ekuthizeni bakhona begcina kuthwesa ke umsoro oqala ke icala lapho ke bese wakhuluma ngodaba le confession udaba lwama statement ofakazi futhi udaba lokuthi kade ikhonjiwe yana ke lapho.
My lord, so with greatest respect, previously, even on the trial, within trial, and subsequently on the trial, when I was busy, particularly under cross-examination, I dealt with the evidence that connects all the accused. And that is found because I was referred to various statements, but the statement which contains the facts, the evidence that I have on each of the accused, I was made to read it in court, and it summarizes all the evidence, and that is A198. That is the application for the warrant of arrest of accused, dated the 23rd of October 2020. Under each accused, the facts, as Advocate Mnisi says, it needs the facts of what evidence did I have. That is a summary of it, although I was directing it to the court, but it was emanating from the docket, not from me, and it is the facts that I presented to the DPP. Now, if I have to be specific as to point by point what is contained, it means I must go through this statement. I've dealt with it.
Go through it again.
Athi ke lapho ke bayadaba lolu ke ummelweni ke banomzana ke buza ngalo ke malana nodaba lamaphuzu lawo kade unake anawo futhi wamikise kuthimba le hlangothi lezabashushisi ekuthizeni abashushisi abakhulu bese bathatha isinqumo ke lapho ke sokuthi yebo asibathwese icala lesigameko lesi kade ngisola ukuthi nisenzile ke lapho ke udaba lolu wakhuluma ngalo ke la enkantolo ngesikhathi icala lihlelwe phansi likhulunywa le enkantolo noma beliqala enkantolo futhi wabuya wakhuluma ngalo lo daba lolu ke ngesikhathi kade bembuza ke imibuzo ngaphakathi ngesikhathi kade kunomzila ngaphakathi komzila noma ngesikhathi kade kunekhulunywa ngokompikiswano kade khona ke la ngaphambi kwenkantolo ke athi khumbule khona njalo lana ke udaba lolu lukhona ke futhi lokuzana ama-facts lawo ke noma amaphuzu lawo ke wabhalile lana ke ngaphakathi kwedocket ke lapho ke futhi umbhalo wakhona ke noma bawumakhe ngokuthi A198 futhi ilanga lakhona ke kade kuyi-23 zenyanga ka-October ngomnyaka ka-2020 ke lapho ke athuma ngaba inkosi enkantolo yamvumela ke uyothi afunde ke lapho ke ukuthi ngabe yini iqukethiwe ngaphakathi kwe-statement leso sesamaphuzu.
Okay, my lord, it reads as follows. I, the undersigned, Bongani Nicholas Genenda, state under oath as follows. I'm employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same act I'm currently stationed at the National Commissioner's Office as the commander of the Cold Case Investigation Unit at the National Commissioner's Office with the rank of a colonel. And then it mentions the service number as well as my cell phone number, my lord. Paragraph 2 reads as follows. I'm the lead investigating officer of phosphorus case 636 of 10/2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 2030 and 2100 hours. The deceased was shot at the house belonging to then his girlfriend, namely Kelly Kumalo. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that two black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witness stated that one of the accused was carrying a firearm purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second accused. The second suspect was described as taller, slender, neatly shaven, and dark in complexion. It is stated under oath that during the robbery in the said house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased Senzo Meyiwa on close range on his chest and exited at the back of his body. The second accused focused on the rest of the witnesses. In the process, one cellular phone belonging to Ms. Kelly Kumalo was robbed by the suspect during the committal of the offense. It is also stated under oath that suspicious suspects were wearing, it is also stated that suspicious suspects wearing specific clothing, amongst others, a hoodie, were standing hidden away only few meters from the crime scene prior to the incident taking place and on their cell phones. It is stated that the suspect fled on foot. The suspects fled on foot, and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identities were compiled through witnesses of these suspects. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 2030 and 2100 hours. The deceased was declared dead on arrival at the hospital on 21/15. Paragraph 3. Investigation revealed that the cell phone which was robbed was picked up through a cell phone towers until the signal was lost, covering the area of phosphorus area. The said cell phone was never recovered to date or even switched on again. The evidence explained hereunder will indicate that the planning of the offense and gathering after incident took place at Phosphorus Hostel. Investigations which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than the robbery or robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa.
Thank you, hold it
No,
there.
please, let him finish. You ask the question, let him finish.
But my lord, I'm busy
No,
taking
no.
note as well.
Yeah, but he must say what he said in that affidavit.
But then when I'm going to take
You've got a
notes,
copy, Mr. Mnisi. You don't have a copy of that affidavit.
I don't have it before me.
Okay, I'll adjourn. Please make a copy for Mr. Mnisi.
Thank you.
Okay. Please.